in the last year alone, I have had so many instances where people call me and they say, hey, Joe, I didn't understand that. I thought I was getting $2 a foot. Now I'm actually paying closer to, $3.50, $4 a foot. Mm-hmm. And I said, well, what kind of lease do you have? They can't answer me. They have no idea what kind of lease. I don't know. I just signed a lease. Well, sure enough, I look at their lease, and as clear as day, it's there. Their cam charges or the triple nets are, sometimes over $1 a foot. So not only are they paying their $2 a foot that they were expecting to pay, now they're paying an additional 50% above that they weren't expecting to pay. Why? When people sign leases, I don't think that a lot of times tenants, especially tenants, I think landlords are a little more savvy, but a lot of times tenants don't give it the level of import that it really deserves. Let's just take, for example, we're in Southern California, so this is not out of the ordinary. In fact, this is probably low. A basic lease, let's just say 5,000 square feet at $250 a square foot. That's just a very basic lease. In fact, you and I know that some of these go for $3, $4 a foot. That basic 5,000 square foot lease for $250 a foot over 5 years, the value of that lease, the value of that contract is $750,000, $750,000. Yeah. That means that when you sign a lease, when a tenant signs a lease, the landlord is expecting a value of $750,000, and the tenant is expecting to shell out $750,000. We had a situation where a tenant who was the junior anchor there, but it wasn't a corporate entity, it was more of a regional entity, moved into a particular center. The question, aside from what kind of lease am I getting into, is I want to know as a tenant, what are the landlord's plans with that particular center? And I'll tell you why. This particular tenant moved in. The landlord had owned the building for forever, for decades. The landlord did not share with the tenant that they were planning on selling it. The landlord had not changed their debt obligation. In fact, it was owned free and clear for forever, for decades. So your tax basis was fairly low. Fast forward, they sold it. The taxes jack up like 800%.
Hi, everybody. This is Jose Luiz Morales. Welcome back to the Morales Group podcast. Today, we have a very special guest. His name is Joe Nuñez. He's an attorney. He specializes in real estate law, estate planning, and business and civil litigation. Today, Joe is going to be talking to us about some of the different things that you as a consumer or even as a landlord, you have to watch out for when doing a commercial real estate lease. And now more than ever, because of COVID-19, it's important to know what type of lease do you have, what are the different types of leases that are available, and what are the small prints in the commercial leases have. So welcome to the show, Joe. How are you?
Doing well, Jose. Thank you for having me. First off, I'm going to apologize to your viewers, listeners, and your followers, because I have watched your podcast in the past and your interviews. By the way, you do a great job. And I have seen where the presenters have a nice audio or visual presentation. I don't have that other than my rambling on. I did put a code on though for you.
No, so. I completely understand. I've done some research, and essentially I know that you're more than qualified, and essentially what we're after is what you have up here right now. So welcome to the show. So I wanted
thank you for having me.
What are the different types of leases, Joe, that are available? Like, let's say that I'm about to rent a commercial building. What are the different leases that are available to somebody when exploring that option?
Okay, I think that's a great question. Let me just start off by saying, when you say what are the types of leases, the way I view a lease is, and the way people should view a lease is, it's a contract. What are the types of contracts? When you sign a lease, what you're essentially doing is you are engaging in a contractual agreement with the landlord. And the reason I say that is because for whatever reason, and I'm not sure why, when people sign leases, I don't think that a lot of times tenants, especially tenants, I think landlords are a little more savvy, but a lot of times tenants don't give it the level of import that it really deserves. Let's just take, for example, we're in Southern California, so this is not out of the ordinary. In fact, this is probably low. A basic lease, let's just say 5,000 square feet at $250 a square foot. That's just a very basic lease. In fact, you and I know that some of these go for $3, $4 a foot. That basic 5,000 square foot lease for $250 a foot over 5 years, the value of that lease, the value of that contract is $750,000, $750,000. Yeah. That means that when you sign a lease, when a tenant signs a lease, the landlord is expecting a value of $750,000, and the tenant is expecting to shell out $750,000. So the reason it's important that you understand this from a contractual standpoint is in case there is a breach, and let's say there's a breach halfway through, and one party does not realize the benefit of their bargain, we're talking major dollars, and that's why there is so much litigation in this particular arena. So as far as your question goes, when you're looking at, well, what are the types of leases? Yes, generally there are numerous types of leases, and it really depends on where the properties are located, how old the commercial buildings are, frankly, who the landlords are, how much debt obligation there is on that particular structure. But you'll have generally what are called the net leases. And the net leases could be either single net, double net, triple net. I'll go into a little bit of the detail, but the net leases basically means that the landlord is getting the rents net of the expenses because they are passing the expenses associated with operating that particular center or that particular building. They're passing those costs down to the tenant. So if you have, for example, just a single net lease, that just generally means that the tenant is responsible for paying the taxes. If you have a double net lease, the tenant is responsible for paying taxes and insurance. If you have a triple net lease, that's generally is where the tenant pays for pretty much everything, taxes, insurance, and your maintenance. And the maintenance has a whole slew of subheadings, sub areas, common area maintenance, repairs, what have you. So those are generally your net leases. You have to be careful on the net leases that you understand how much you're going to be paying, because I have had, oh goodness, I can't count on two hands. Just in the last year alone, I have had so many instances where people call me and they say, hey Joe, I didn't understand that. I thought I was getting $2 a foot. Now I'm actually paying closer to $3.50, $4 a foot. And I said, well, what kind of lease do you have? They can't answer me. They have no idea what kind of lease. I don't know. I just signed a lease. Well, sure enough, I look at their lease, and as clear as day, it's there. Their cam charges or the triple nets are sometimes over $1 a foot. So not only are they paying their $2 a foot that they were expecting to pay, now they're paying an additional 50% above that they weren't expecting to pay, and that's usually the unsuspecting tenant who hasn't really engaged in a negotiation before. But that is also true with tenants who have a little more experience. Those triple nets are subject to change. I always say they are not static, they're dynamic, meaning if there is a reassessment, if there is a change in contracts, those charges are subject to change. So your base rent is probably not, you probably fix that in. Your charges, unless you have somebody who negotiated it on your behalf, are probably going to do this.
So essentially, it should go up, essentially, based on if there's a reassessment in taxes. They think that they're paying this amount, but essentially over time that could go up. And it also sounds like the first question that somebody should ask when considering signing up for a commercial lease or a commercial contract is what type of lease are they signing up for? Because depending on that, that's going to play a big factor as to what they're really paying. So it's more than just how much am I paying a square foot? It's what type of lease is it? Because that's going to play a factor in it as well too.
Absolutely. Let me give you a little horror story. This happened to me, or not, didn't happen to me. This happened to a client, and I'll never disclose client names or companies or what have you. But we had a situation where a tenant who was the junior anchor there, but it wasn't a corporate entity. It was more of a regional entity. Moved into a particular center. The question, aside from what kind of lease am I getting into, is I want to know as a tenant, what are the landlord's plans with that particular center? And I'll tell you why. This particular tenant moved in. The landlord had owned the building for forever, for decades. The landlord did not share with the tenant that they were planning on selling it. The landlord had not changed their debt obligation. In fact, it was owned free and clear for forever, for decades. So your tax basis was fairly low. Fast forward, they sold it. The taxes jack up like 800%, because we're talking original assessment from God knows when. Now this guy is on the hook for paying essentially 4 or 5 times the amount that he thought he was going to be paying. But the lease was drafted in such a way that they're responsible for their proportionate share of taxes.
Wow.
Which, irrespective of sale or what have you. So anyhow, I always want to know what's going to happen, because you want to plan ahead. So yes, and so going back to the leases, and it's not just you could try to see if you could get a gross lease, so that essentially a gross lease is, I would say, the opposite of your net leases, in that the landlord takes on the majority of the debt and the debt obligations, maintenance and what have you. The downside of the gross lease is sometimes a gross lease would have a much higher rent basis. Not always, but sometimes. And so that's kind of, you want to make sure that you understand that very, very early on. And obviously there are some other types of hybrids, modified gross, but I'll answer that question if you want me to get into more detail.
Yeah, I was going to say that gross lease is more like straightforward. Essentially, it's more like, hey, look, this is what you're paying, and you're not responsible for any taxes, maintenance, or any sort of expenses on the building. Now, for the viewer, what Joe just described is that whenever in that situation, the tenant had a net lease, some sort of net lease, and the owner, when they purchased it, the taxes were based on that purchase price. And when they sold it, the taxes went up because obviously they sold it at a much higher price. So essentially in the net lease situation, that made it so that the amount that the tenant was responsible for was a lot higher. So big aha, if you're signing up for a lease, it's very important to ask, like, okay, what are the plans? If you're signing up for a net lease, what are the plans for the owner? And maybe even how long have you owned the building for? Because if they've owned it for 20, 30 years and they're planning on selling it and you're responsible for taxes, that tax can go really high now. So just out of curiosity, what was the result of that case, Joe? Like, what ended up happening? What was the tenant suing the landlord for not disclosing that, and how did that play out? Just really quick.
My client, unfortunately, did not have much recourse. So my client, again, trying to maintain confidentiality, they were in a position where they were forced, and sometimes there is what's called efficient breach. They were forced to breach because they couldn't afford it. And we ended up, it was a settlement situation where we ended up settling, and essentially it was a buyout type of arrangement. But going back to that, to the question you said, sometimes a gross lease sounds like it's much more efficient. In theory, it is, but that's why, however, it's not necessarily always to the benefit of the landlord. You don't see a lot of gross leases because it stymies your ability to alienate your property, meaning it stymies your ability to perhaps obtain financing to sell the property. So you're not going to see a lot of gross leases. That's why I kind of just started with your net lease options, which is the predominant type of lease that's out there. Now you do see a lot of times gross leases in other types of settings, the industrial, manufacturing, types of settings. That's where it's generally more common. At least that's what I've seen from the legal practice. I'm sure there are commercial brokers out there that would probably argue, but from a legal standpoint, the cases that I've gone that are related to gross leases tend to be in that arena.
Great. Now, the only thing, you brought up a junior anchor. I know that some of my viewers are residential. Some of my viewers may not know what that is. Can you just share very quickly what a junior anchor is? That way, whenever they run into that term, essentially they're familiar with the meaning?
Sure. A junior anchor, just envision a shopping center where you have like your main anchor. That means your anchor is your predominant box, your big box store, your big box retail in a center, say like a Ralph's or a Albertsons. And then you have another big box, but they're not equal in size. Perhaps they're half the size. Let's say a 99-cent store or a Dollar Tree type store. That 99-cent store, Dollar Tree, they're an anchor because they're bigger than all the small carve out, the insurance, the Subway sandwich shops, but they're not. They're junior to the main anchor, to the predominant anchor. And I think what that question does is that allows me to segue into the next point, is that when you are negotiating a lease, when you ask, all right, what kind of lease am I getting into? You always have to understand as your leverage. You have to understand your leverage as a landlord. You have to understand your leverage as a tenant. And the reason is because these are contracts, it behooves you to negotiate all of the terms in your favor. So most of the time, what's going to happen is a landlord is going to hand you a lease that is 100% landlord oriented. Every single clause, every provision favors the landlord. Mm-hmm. Your job is to bring that over from the left or from the right and bring it over to your left, closer to you. And that's what I mean. It's not just about the term. It's not just about how much I'm paying per month and how many years. It's every other clause. It's every other provision, because that is what begets your litigation, not understanding all of the fine print. And that's where I think it behooves most, tenants and frankly landlords to work with a competent commercial broker or a attorney who could review and assist on that particular lease. Anyway, I'm not sure if you were going to ask a question about that.
Yeah. What's the last? And I hear an echo. Do you have it playing? Yeah.
I hear an echo. I'm not sure where that's coming from, but I do hear it.
Okay. What I was going to ask you is, what is a percentage lease? Do you know what that is, and roughly what is it? That way we can move on to the next.
Yeah. So a percentage lease or a percentage of sales lease, it just means, and this is generally for the retailer, the landlord takes a percentage of sales each month or year, or depending on when they do the reconciliations, they'll take a percentage of sales for the business. So on top of the regular base rent, whatever that may be, and if you have a net lease, on top of those net charges, they will also take a percentage of what you make. I have seen them as low as 2%, and I've seen them as high as 10%. Really, it depends on the type of business, depends on where the business is located. I would always, clearly it's not in the best interest, in my opinion, of the retailer to sign that, because now they're giving away a percentage of their sales. Now, if they absolutely have to be in a geographic region where they know that the sales are going to be X amount, they may be okay with shelling out 5% of their sales. So as far as what the standard is, it's kind of like asking a residential real estate agent, what's the standard commission? Well, there is no such thing. Everything is absolutely negotiable. And people who say, well, there's a standard. Well, no, there's not. It could be negotiated. Like I said, I've seen it all over the place. Generally, I tend to see between the 5 and 7%, but it could be truly negotiated.
Yeah.
So that's what a percentage lease is generally refers to.
Yeah. What I also gathered from that is that depending on what type of lease a landlord has, that could impact their ability to refinance the building, that could impact their ability to sell the building as well too, because prospective buyers are going to be looking at that type of information when deciding what to offer for the building. So not only from a tenant perspective, but it's really important from a landlord perspective to structure your lease the right way. That way, if you are in a position where you do have to sell the building, you're basically putting yourself in a position where you're not hurting yourself by the type of lease that you have, and you actually put yourself where you're actually helping yourself and can help you essentially maximize the dollar value of that property. So let's just go over a couple of really quick scenarios. What are the most common types for these types of businesses? So like, let's say I'll name a barbershop or restaurant, retail store, doctor's office, and attorney's office. Are all of these net leases, or are they different types of leases?
Again, I hate to kind of use the played out cliche, it depends, but it really depends. There is no right or wrong way. It really depends on where the barbershop, the restaurant, where the different retailer wants to set up shop. If they want to set up shop in a particular center, and that center is a triple net center, meaning that the landlord
only does
absolutely, that's all they're going to do is they're going to pass down the expenses to the tenant. Well, if they want to go in there bad enough, they're going to be in a triple net situation. And it's very rare. It's almost, I'm not going to say it's unheard of, but it's very rare that in a particular center, somebody is going to have a gross lease and your neighbor, your immediate adjacent neighbor, is going to have a triple net lease. That just doesn't happen because number one, it doesn't happen because, like you were saying, these landlords are beholden to their financing. They have to meet a particular threshold as a function of their financing or their debt obligations. The other reason it doesn't happen is you may actually bring about a mutiny within your own center, a little bit of chaos. Hey, how come they're not paying their proportionate share? Or now that I'm paying X, am I actually paying for his part of utilities? Am I paying for his part of the center maintenance? So you want to maintain uniformity. So to answer your question, it really depends on the actual center itself. And it depends on the landlord. Now, I think the better question is, how if a tenant is going to, like a barbershop or a retailer, if they are going to go into a particular center, what can they do to position themselves in the best possible place, operationally and financially? And I do probably 70% of my work is landlord based, 30% is I represent tenants. But let's start off with the tenants, since we kind of are talking about the tenants. If I were a tenant, I want to know, all right, I know they're going to give me this contract. By the way, if I've heard so many times when I've asked a tenant, why did you sign this lease? Well, they told me that that's the only lease they use. Well, they told me that that's the one we have to use. That's nonsense. Just like I said with the percentage, there is no such thing. It's a contract. The contract could be negotiated. Now, if that is the landlord's general base contract, that's fine. It doesn't mean that the tenant does not have the right to ask or to negotiate some of those terms. Now, again, it depends on your leverage. If you are a 200 square foot sandwich shop that's never had a sandwich shop before, and there are 10 other offers, chances are the landlord is going to say, go fly a kite. You're going to use my lease, or I'm going to take the next guy. So always understand your leverage. But assuming that like now, the forecast is, you're probably going to see a good deal of vacancies, or, let's just backtrack 10 years ago when you had a glut of vacancies in commercial spaces. If you're in a good position, you could truly negotiate that. And the place that I would start, if I were a tenant, is make sure that aside from, I say build escape hatches. I want to build as many escape hatches as possible. Mm-hmm. I know that I'm getting into this contract. What are the ways that I could get out of this contract? That's what I mean by an escape hatch. So that's kind of like my mindset. If I'm it sounds somewhat underhanded, but you're always preparing kind of, you're hoping for the best. You're hoping for the best, preparing for the worst. So one of the ways that I try to build an escape hatch is I make sure that I build in what's called a go dark provision. Meaning, let's just say, for example, that I have a lease and I have overhead, and every month I'm losing money because my overhead is so high and my operation is just not successful. You're losing a lot of money. It may actually be more efficient for you to close down and continue to pay rent as opposed to continue to operate in a particular business or in a particular location. I had that with a particular client where they were spending more money by remaining open than they would just to pay the rent. So what a go dark provision allows a tenant to do is to essentially close up shop, continue. Yeah, obviously they still have their contractual obligation, but at least they're limiting some of their losses. That's one of the areas. The other thing that I would absolutely negotiate is I would negotiate, let's say I sign a 5-year lease, 10-year lease, doesn't matter what it is. I would try to negotiate that somewhere in between, let's say after year 2, after year 3, if I don't meet my economic thresholds that I have set out for myself, that I have the right to terminate that lease. Now, will a landlord go for that? Probably not, but that's where the negotiation goes. That's where the negotiation comes into play, because here's the deal. The landlord will also know, especially if the landlord, like I said, doesn't have a lot of leverage, they'll know that if that particular tenant is not successful, they're probably going to breach anyway, and it's probably going to cost them just as much trying to recapture that. So what you do in that instance is set up kind of like a premarital agreement, a prenup. Hey, if it doesn't work out after 3 years, we're going to back out. I'll go ahead and pay you, let's say, 6 months of rent at that point. I'll go ahead and pay you whatever, 6 months, and you could keep my deposit. So you set out the terms in advance. It doesn't happen a lot, but when I'm working with tenants whose businesses have not been as established, that's one thing that I always try to write into their lease, is basically given that little way out. And sometimes I've been successful. Sometimes I've had the door shut on me. But if you don't ask, if you don't try, yeah, you'll never know. One of the other things for a tenant, it's very important, is you were talking about barbershops. You were talking about other types of establishments. If you're going to go into a particular center, it's very important that you try to negotiate an exclusive use for your business. Meaning, if I'm a barbershop, I don't want a barbershop opening up next to me. So as a condition of the lease, I am going to have that landlord write into the lease, I will not, so long as you're in my center, I'm not going to lease to another XYZ, barbershop, sandwich shop, whatever it is. You'd be surprised how many times people don't write that in, and sure enough, there's I don't know, and I don't want to identify anybody, but there's a Palateria X here. On the next week, there's a Palateria X right next to them. So now they're kind of splitting the pie. So anyhow, so you want to try to negotiate that into your lease. You want to also make sure that as another escape hatch, let's say things aren't going well, or you want to decide to sell or lease, that you have a favorable assignment or subletting clause in your lease as a tenant. You don't want an overly restrictive clause, and worse yet, you don't want something that completely prohibits you. You don't want language that completely prohibits you from subleasing or assigning your interest in that particular space. So that's something that I would always try to negotiate in advance. Very important is the options, something people don't think about, especially if you have a good product or if you're in a good location. In fact, I had this earlier this morning. I was negotiating a lease for a young lady, and I'll just say the location in Malibu. Malibu is a high rent, high area, and her particular product fits perfectly into the Malibu culture. She only had a 1-year lease term, which kind of shocked me because I would have preferred something longer, but she was okay with that. However, she did not build in any options. So the problem is this: if she's doing really well and she establishes a following at this particular site, that lease automatically terminates at the end of the year. There is nothing to keep the landlord from a little, I'll say, little quasi extortion. Well, if you want to stay here, you were paying $3 a foot. Now you have to pay me $5 or $6 a foot. So what you do to kind of prevent from that situation is you build in your options. You build in and say, hey, look, I have the right to exercise, say, 2 or 3 successive 1-year options. If you have a 5-year term, 2 or 3 successive 5-year options. Now, if you don't, it doesn't mean that you have to exercise them. It's your option. You could decide to extend or not extend. But that way, if you do extend, you know that for the most part, and you also have to negotiate this, is that your rent will remain somewhat consistent during your entire duration of your tenancy. Now, clearly, most leases will have general escalation clauses, meaning percent increases annually, and to account for cost of living and your CPI, what have you. But that just goes with the territory. So that's what I would do if I were a tenant. Exclusives. Oh, a big one right now is, and this is, we probably have negotiated something like 30 workouts for tenants as a result of COVID, is your force majeure clauses. Or what the heck is a force majeure? What the hell does force majeure even mean? Force majeure basically means higher power, acts of God, whatever you want to say, different definitions. I forgot what the actual term means. Goodness gracious, shame on me. But point is, force majeure, it could be, the clause itself could be slanted either direction, depending on who's drafting it, clearly. I have drafted force majeure clauses for landlords where I say, no matter what happens, if there's an earthquake, if there's a tornado, if there is strikes, if you don't have the proper, if there are logistics issues, you can't get your supplies in, no matter what happens, we could probably give you some concessions in terms of the time that we do certain deliveries, but you will still have your affirmative duty to pay rent, and you're not relieved from paying rent. Mm-hmm. Conversely, the ones that I've been drafting lately are, I write everything under the sun, including pandemics, epidemics that are bacteriological based, that are virus based. And I say, if we are prevented from operating because of an act of God, as they're known, or because of any other calamity, we are going to be excused from paying rent during the duration of that. Now, that's an example of the clause itself could have a lot of teeth. It could have no teeth, depending on what side you're negotiating. Mm-hmm. Clearly, if you're signing a landlord's lease, he's going to say, no matter what happens, you're on the hook for it. And guess what? It's a contract. You're on the hook for it. So you want to make sure that you look at that particular language. The other thing that a tenant should be on the lookout for, and this is one thing that landlords are notorious for, is making sure that you understand what contracts you're on the hook for. So it was like, what do you mean what contracts I'm on the hook for? I'm on the hook for the lease. Well, not necessarily. It's very common that a commercial landlord will write into the lease that the tenant will also maintain, for example, a contract for servicing of the HVAC unit, that they'll maintain a contract for pest control services, perhaps that they will get additional insurance to cover business interruption, as we're saying now. All of those provisions are written into a lease. And if you don't follow that, that subjects you to a claim of breach and perhaps a termination of that particular lease. So you have to understand that that's going to be in the fine print, not in the first 2 pages where you see all your terms. That's going to be on the back end. So you have to understand that, because I have had situations where we have terminated, because I told you I represent 70% landlords, where we have terminated tenants because they have been unable to provide certain insurances that we have called for, or my client has called for, because they have not maintained the necessary contracts in place. So you have to understand what your obligation is as a tenant beyond the rent and beyond any other charges that are expressly stated in your first, like I said, first couple of pages.
Yeah, no, I agree with you. And I think that scenario where you talked about the Malibu girl with the business, it's something that a lot of people don't think about to build in the option. The thing that I think about there is leverage. If you have the options built into it, you pretty much have the option of renewing it. If you don't have the option, now the landlord has all the leverage basically, and the landlord can say, well, look, we're gonna, now it's $3, $4, $5 a foot. So I think that's really good. I wanted to ask you one question about the go dark period. So like, assuming that you don't have that go dark clause, does that mean that the tenant would have to remain the doors open no matter what, even if it's costing him X amount of dollars to stay open versus just closing it and still paying the rent?
So now what you're asking is, what's the flip side of that?
Mm-hmm.
If I'm the landlord, the flip side of go dark is what's called continuous operation. I'm going to make sure that I have a continuous operation clause in my lease. And I draft a lot of these for landlords, and I have that in every single one of my leases, is that I am going to force, especially if I'm dealing with a bigger tenant, I am going to force them to remain open. And the reason,
almost like an anchor or a junior tenant, right? Now,
exactly. So,
why would you want to force them to remain open?
Because here, let's just say I'm representing a big grocery store, and they're the only anchor. But on each side of the grocery store, there are 5 small units. Let's just say there's an insurance broker, there's a dentist, there's a sandwich shop, there is named palateria. There's on the other side, you have whatever, a laundromat, you have whatever it is, maybe a check advance place. Well, if I don't write in a continuous operation that you're going to keep operating, and that anchor goes dark, guess what happens to the amount of foot traffic in that center? It just disappears. So
now
guess
everybody's hurting in that situation.
So now everybody's hurting, and chances are all of those other smaller tenants are probably not going to be able to meet their sales figures, their debt, because they depend on that anchor to bring in that traffic. So now that anchor leaving hurts your entire operation, your entire center. And remember, because your debt structure is tied to how much income you're generating, you can't afford to not have a ironclad agreement, especially with your larger tenants. And that's why, I mean, these are $1 million. We talked about 750,000. Well, it's not out of the ordinary that these are $20, $30 million contracts, and you have to solidify them. And it's a very important on attorneys on both sides that, whoever, depending on what side you're representing, you could lose your financing, or they could call the loan, the bank. There have been situations where banks will actually call the loans, meaning that they would accelerate them if you don't meet certain thresholds. So that's a great question. But generally, if I'm a landlord, I'm going to make you continue operating for that reason. In fact, in some instances, I will write in, not only are they going to continue operating, but if they don't, now you're going to pay 1.5% rent. And because it's a contract, if they agree to it, they agree to it. It's not my job to do the tenant's job. If I'm representing the landlord, if I'm representing the tenant, it's not my job to represent the landlord. So I'm always going to skew the agreement depending on who I'm representing.
Yeah. No, and I think it's important because I've personally witnessed, like we're building a laundromat in Oxnard right now. And I was talking to another owner of another laundromat, and he tells me that he had to shut down his laundromat because the owner put another laundromat in the same shopping center. So it's never got exclusive. I mean, essentially, some of these clauses are really important. And I think what you said is really important, that depending on who you're representing, that depends on what kind of clauses you're going to include in the contract. And I do the same thing as a real estate agent. Like if I'm representing a buyer, there's certain clauses that protect the buyer. We're representing a seller, there's certain clauses that protect the seller and don't protect the buyer. And I think it's important to have somebody like that on your side, whether it's a realtor, an attorney, or whoever it may be as well. So I think that's really great. What I was going to ask you is, now let's say that you're able to come to an agreement on the lease, you're able to agree on price, net lease, whatever. Who is responsible for improving the building? Like meaning like getting it operational? Is that something that's negotiable? Is that something that's typically paid by the landlord? Is that something that the tenant typically pays? Tell me more about that.
Okay, so that's another great question. So that really just depends on what you negotiate. Mm-hmm. And so let's just take your typical fairly good size center, your 10, 11, 12 acre center that has perhaps an anchor, junior anchor, and a number of stores, perhaps an out parcel with the Jack in the Box, McDonald's, whatever it is. What most of these centers are going to be your triple net type of centers, meaning that the landlord will collect the rents, but they're also going to be collecting the additional costs, including the maintenance. So we call it common area maintenance. That's so what they're doing is the landlord has contracts. Let's just say for building a new roof, for repaving the asphalt in the center, for painting the shopping center, for lighting. Those contracts, those costs, those maintenance costs, when you have a triple net, get passed down to the tenants, usually on a pro rata proportionate share basis. Meaning if a tenant is occupying 5% of the square footage of the entire center, they're going to be responsible for 5% of those maintenance costs. And that's, so I talk about how in some instances people, thought they were paying $2, but now when they get their bill, it's actually $2 plus another $1.50 on top of that. Well, that is your maintenance cost, your tax costs, your utility costs that get passed down. If you are a major anchor, it is also not out of the ordinary to force the anchor to maintain the premises with, let's say, and maintain a particular aesthetic to the building. It's not uncommon that you're going to see a clause, for example, where I say, Anchor X, you have to repaint the exterior of the store every 5 years. You have to do this every, 6, 7 years. You could actually pass down those costs to your anchors. And it's not as common that you have passed down those costs to the smaller centers, but it is absolutely common. You're going to see this 99% of the time that those costs are passed down to the tenants. So who pays for it? The tenants. Who arranges for the contracts for the work to be done? The landlord. Unless you negotiated that the particular tenant will take care of, let's say, their own roof. And that's one thing that you can negotiate, where the roof for that particular space is going to be maintained by either the tenant or the landlord. HVAC is going to be maintained by tenant or landlord. So going back to what I said, this is a contract. There is no right or wrong. It could go either way, depending on your clout, on your leverage, and how much one side wants to be there versus how much the other side wants you to be there. So
for the build out of the initial move-in, where the landlord pays for the build out versus the tenant, depending on who the tenant is, or is that the tenant typically responsible for the build out obviously, I mean, I would imagine that it's something that's negotiable as well too, right? The initial build out.
Absolutely. And let me just tell you, the initial build outs, sometimes you're talking major dollars. If you are, just operating like a warehouse space, probably not a lot of money in terms of build out space. If you're going to set up offices, let's just say you're going into a center and you're building out a dental practice. If you're building out whatever it is, grocery store, the amount of dollars associated with building that out is going to run you in the hundreds of thousands, and for your bigger tenants in the millions of dollars. So you clearly negotiate that into the lease. So you say, hey, landlord, you're going to give me a $50 a square foot credit, not per year or whatever it is. If it's 5,000 square feet, you're going to give me a $25 per square foot general credit to build out. Where you're going to negotiate is, well, let's talk about the entire value of the lease. If the entire value of the lease is $500,000, the landlord is not going to pay $250,000 for your TIs. And TIs, I mean, it's TIs are tenant improvements. So when I say tenant improvements, I'm talking about the build outs. So you have to understand what value, and I've had tenants who are completely unreasonable, where the entire value of a lease could be $1 million, but they want me to ask the tenant to pay $750,000 of work to their spaces. That's ridiculous. It's not going to happen. But I've also had instances where your landlord wants a particular tenant so badly because they're going to be, it's a national brand, perhaps it's an anchor. They're going to increase the value of your center that the landlord themselves is willing to give the tenant a very hefty allowance so that it could subsidize their moving costs. Now, if the landlord is going to do that because they really want this, put yourself in the landlord's shoes. If I'm going to give a company $500,000 or $1 million, let's say like on a very large lease, to build out a particular space, and if you don't have good representation, that's probably where you're going to leave it. Okay, I'll give you $1 million. Hey, I'm happy because tenant XYZ is coming into my center. Well, what happened is that tenant XYZ breaches the lease and now they leave after year 3. And you never actually recovered your upfront costs. So it's very important that if you're going to do that, that landlords draft in what's called a recapture provision, meaning that any TIs that they paid to induce the tenant to come into their center, should the tenant breach, they have the ability to recapture those costs in court. So, and it's not just TIs. You could do a recapture provision. Let's just say that a tenant is struggling and they say, hey, we want a little bit of rent abatement or a rent deferment. We want a little bit of a break. You could set it out. You could set out as a landlord your recapture provisions. Whereas if you give them a break and they breach anyway, now when you go to court to capture your benefit of your contract, you actually not only get the reduced price, but you get what you would have been entitled to from the very get-go, including any costs, any incentives that you put out. That's a very important clause that even some experienced landlords don't include in their leases.
The recapture. Okay. Yeah, well, that makes sense. Okay, good. Now, are commercial leases recourse? Meaning, can the landlord, like, let's say that I sign a 10-year lease worth $1 million, and for whatever reason I can't continue there after year 3. Am I personally liable, or is the business personally liable? And how does that work?
Yeah. So just to kind of analogize it, when people generally talk about recourse versus non-recourse, they're generally talking about mortgages. Is a mortgage a recourse loan or a non-recourse loan? Meaning, if the bank has to pick up that loan, if they have to foreclose, does the bank still have the ability to go after the borrower after they have foreclosed? If they don't, that's non-recourse. If they do, that's recourse. It doesn't quite work the same way in the commercial setting because these are contracts. If you breach your contract, the landlord or the tenant, most often the landlord, will absolutely have a right to go and seek legal remedies, including that value of that contract that they did not receive. So if they were expecting to receive $1 million and they only got 300,000 of that because person breached after 3 years, they could go and try to collect 700. Now, are they going to collect 700,000? Probably not. because one thing that we have to realize in a commercial lease, there and in California, and as there is in many jurisdictions, there is what's called an affirmative duty to mitigate. Now, that means that, let's just say you have a 5-year lease as a tenant. You breach it because your business just dies after year 3. Can the landlord just sit back, twiddle his or her thumbs, and just wait till the contract keeps accumulating, and then at year 5 say, hey, you didn't pay, I'm going to go try to collect for those 2 years? No, you can't do that. The landlord has an obligation, and if you're a tenant, by the way, you want to make sure that you draft this into the agreement, that there is a duty to mitigate. And that's where, again, tenants don't know this stuff. So that means that the landlord has an obligation from the time that they are aware of that breach to start trying to replace that tenant. So so you can't just, as a landlord, you can't just let the tenant keep accruing charges. You have to also give to market it. Now, all of those costs, the marketing costs, the if say you bring somebody in at a lesser amount, you're entitled to charge the person who breached the difference and any expenses that were incurred because of that breach. So that's called a duty to mitigate. Landlords generally have that. So to answer your question, yes, they could go after you. If you are an individual, a sole proprietor, they'll go after you. And very aggressive landlords will go after you. And if you don't pay, they'll file a judgment and essentially start collection actions on you. And they have the right to do that. That's why I always say, if you're going to open business, here's another thing. If you're going to open business, try to have it set up as a legal entity, because you have limited liability. Make sure that you run that entity and meet all the formalities so that they can't go after you personally. But if you are a tenant, be very careful of the personal guarantee. You've heard the personal guarantee in the lease.
Yeah.
A landlord, even if there's a corporation coming in, they're going to want a personal guarantee somewhere. If you're a tenant and you have a corporation and you've been in existence, say 10 years, you have 2 or 3 other retail shops somewhere else, your argument is going to be, look, my corporation is established. It stands on its own feet. There's no reason for us to do a personal guarantee. When I represent tenants, I make sure that I try to leave out the personal guarantees. Obviously, if it's a first-time business owner, you're probably not going to be successful. If you're a little more established, say, look, here are my financials. Here are my profit and loss statements. Here are my last 4 or 5 years returns. This should be enough for it to stand on its own, so that you don't require me to personally guarantee that lease. I don't want to be on the hook for my corporation.
Yeah, absolutely. Okay, good. Last question. So just right now, with everything going on with COVID-19 and basically people being forced to close their business, what are some of the things as it relates to commercial leases that you're seeing? And what should somebody do if they're in a position where maybe they can't afford to stay in business, or maybe they can't afford to stay due? And lastly, what can a landlord do if they're in a situation where they received a letter from California Pizza Kitchen or someone and says, hey, look, we're not paying rent for the next 6 months or until this thing passes over? So it's kind of like 3 questions in one, but if you can elaborate on that, that would be extremely helpful.
Yeah, that's a very good, nuanced, complex question, but I'm going to try to break it down. The first thing you have to do is understand what your respective rights are. You have to understand what your rights are as a tenant. You have to understand what your rights are as a landlord. So let's start with this COVID pandemic and its impact on tenants. What we know is there is a moratorium on all eviction actions. We know that, meaning a landlord cannot evict you during, while we have these stay-at-home orders and what have you, until the executive order is lifted. However, that does not protect you, and that does not preclude a tenant from having to pay rent. Now, what if the tenant cannot pay rent because they've been closed? Well, one of the things that we've been doing is we have been negotiating workouts with the respective landlords. And workouts is we have asked for either abatements and some rent, say, hey, can you please forgive 1 month? Most landlords, I'll tell you right now, are not doing it. Some are, but most aren't. What most landlords are doing is, look, if you're going to be closed for 3 months, we understand that. We're just going to forbear the rent that's due. So if you've accumulated 3 months where you didn't pay, and I have this, and I've probably have 30 different iterations of this, we're not going to charge you late fees, but you're going to have 6 months, 9 months, or up to a year to pay that 3 months that you did not pay. That's what's called a forbearance. In some instances, we have negotiated hybrid models. Now, from the landlord standpoint, keep in mind, the landlord still has their debt obligation to the bank. And if they're not collecting these rents, people forget. People a lot think that the landlords are deep pockets. A lot of times they are. Sometimes the debt obligation on the particular center or in the particular building is such that there's very little margin and they need those rents. So I see it from both sides because I represent both sides. So, but the landlords also know that the tenants cannot just say, I'm not going to pay, because you could go after the tenant now you can't go after them now, but once everything is lifted, you could go after the tenants for non-payment. Let's say that they don't agree to a particular workout that you're offering. Well, the tenant can just say, no, I'm not going to pay, and I'm not going to pay, because they have a duty to pay. You have a contract. And unless you have an out clause, like it's actually written in your clause, because this is a contract, that should there be a pandemic, you're not going to pay rent, which I have yet to see. I've seen a couple, but not very many. You're bound. So your best bet as a tenant who has been struggling is to do an amicable workout with your landlord. Hopefully, the landlord abates some rent, but at least you could pretty much rest assured that at worst they're going to give you a forbearance, and you're going to have some time to pay that off.
That's great. Good. Anything else, Joe, that you think that we should add, or anything else that we might have missed?
Well, I mean, this is, there's a whole lot. There are courses in commercial real estate that take 2 or 3 years. We talked for about 45 minutes. So there's a whole lot that we missed, but I guess the nutshell of this, or just to kind of wrap it up, put a bow on it, is make sure that you don't go in blindly. Make sure that you always understand to the best of your ability. Work with your broker, work with your attorney to understand every aspect of your lease. And if you're a landlord, this is a very good time for you to take a look at your lease also. You may be using a lease that you've had for 5 years. This is a good time to look at that and see, hey, where can we tweak it? Where can we add additional coverages? Because I expect some landlords are going to see vacancies down the road. Same thing with the tenants. Understand your rights, understand your leverage. And once you know that, you'll be in a better position to structure something to your advantage.
Joe, one of the best shows, one of the most educational shows that I've had on the show. I really have enjoyed this. And I feel that it's a lot of value that you shared with our viewers. And I think that you shared a lot of information. Even for me, I think it kind of shed some light as to how to think about this. So I really appreciate you coming on the show. I really appreciate you sharing this. And who knows, if I keep receiving questions about commercial loans, commercial leases, we might eventually have to do a part 2.
Anytime, I'll be ready, and I'll be more prepared. Perhaps I'll have some really fancy visuals for you also. No,
I think it was great, man. I really appreciate it. All right, everybody. So this has been episode number 36 of the Morales Group Show. Joe Nuñez, as you guys know, shared a lot of valuable information. Last thing, Joe, where can they get a hold of you if they had any questions about estate planning, civil and business litigation, and real estate as well too?
Yeah. So I'm going to get. It's our website is thewestfordlaw.com. Our office number is 213-330-4215. We're all over the internet. We have office in Los Angeles, Long Beach, and in the Central Valley, the Central San Joaquin Valley. So we cover a good amount of California. I do a lot of work out in your neck of the woods, Ventura County, and even Santa Barbara County as well.
Awesome, Joe. Thank you so much. Really appreciate it.
No problem.